Hi, my name is My Love Williams, and I am thrilled to discuss an issue that falls within the intersection of the educational field, legal, and ethical matters: the constitutional rights of students on educational campuses. As the educational administrator, understanding these rights is crucial in ensuring safety of students, but within the legal framework. The constitutional rights of students at the school are simply based on the First, Fourth, and 14th Amendments. In the past, the rights of students have been extended tremendously on the 1960s and 1970s. The case Tinker versus the Supreme Court, the principle stating that students do not divest themselves of their constitutional freedom of speech or expression on the schoolhouse door, is in the brainchild of Des Moines, 1969. Tinker confirmed that when students' expression causes material disruption to learning or violation of the rights of other people, schools could restrict them. New Jersey versus TLO, 1985, ruled that Fourth Amendment protection against unreasonable searches of students applied in school, yet at a reduced standard. The school official need only reasonable suspicion, but not probable cause. Morse versus Frederick, 2007, enables schools to censor particular types of speech like pro-drug messages. These decisions combine to bring up a legal conflict. On the one hand, schools have to be safe and order in order. On the other hand, students have constitutional rights. Rules on the Constitution that concern students in different school environments differ. In public schools, being a governmental structure, the public schools are subject to the Constitution. The right of free speech, due process, and freedom against unreasonable searches of students is applicable here. In charter schools, many charter schools are considered to be state schools and subject to the same constitutional restrictions depending on the law of the state. But there are legal ambiguities in the operation of some charters of private organization. The difference between charters and courts is that there are states where charters are viewed as actors of the state and states where they are not. In private schools, they do not act as government agents and are not normally subjected to adhere to the constitutional protection. Nevertheless, there can still be commitments imposed by the contractual agreements, accreditation standards, or state statutes. Virtual school and hybrid schooling makes the analysis difficult. The digital speech, off-campus behavior, and school authorities still are being established by courts. Current issues: student free speech on social media. The scope of the authority of the school to monitor social media use of students, even when they are not in school, can be seen as one of the hottest legal issues of the present day. This case Hamilton, Mahoney Area School District versus BL 2021. The Snapchat rant was a profanity-filled post by a high school cheerleader off campus and out of school. She sued and was suspended by the school cheer team. The Supreme Court was ruling in her favor, saying that schools are more limited in regulating student speech, which takes place off campus. Nevertheless, the court also highlighted that there are cases when bullying, threats, harassment, or even cheating are permitted, and thus the intervention could still be made. But this is a two-sided issue. Side A, defending students' free speech. Students need their own space and self-expression that is not within the school authority. Adolescent communication usually happens mostly on social media. Access by school can threaten to infringe the First Amendment rights of students. Side B would be keeping commercial and non harmful issues out of schools. There are a lot of ways online behavior influences the school climate. Cyberbullying, threats, and harassment do not remain outside the campus. The leaders should guard students and employees against online induced harm. The courts have recognized that off campus speech can be censored in cases where they cause much disruption. Another applicable case that is still under litigation in the lower courts is the Shin versus the Albany United School District 2022 to 2024. Um, there was a racist post on Instagram that caused major disruption in the school environment. School discipline was affirmed by an argument that immensely harassing school environment provides administrative authority. My educational leadership position is that schools should put the security of students first and not bypass constitutional rights. Schools are only expected to intervene when off campus speech leads to or is likely to lead to significant interference, or harm. This secures the learning environment and the constitutional rights of the students, which is in line with the ethical principles of fairness, due process, and appreciation of human beings. Thank you for having me. I would like to believe that based on this discussion, our audience could be in a better position to understand the fine line between rights and responsibilities in the current educational environment. Thank you.